the intent of it is to reach out to people with notable practices in the area, and primarily to try and bring together Australians far and wide, practicing all over the world in this interesting field, together with some guests. Today, we've got the benefit of hearing from Professor Zachary Douglas KC and Jailin Ho. They're both notable and accomplished practitioners in international arbitration, particularly with focuses on investment treaty arbitration. Zachary is an arbitrator, has been an arbitrator in more than 170 cases, including more than 50 investment treaty arbitrations. He practices as counsel before the English courts, international tribunals, as I said, he's King's Counsel in London. He's a professor of international law at the Graduate Institute in Geneva, formerly a member of the Faculty of Law at Cambridge University. As many will know, he publishes widely in the fields of public and private international law, and is an author of one of the leading texts on investment arbitration. I think from Melbourne originally, Zachary. Jailin is a senior associate at King and Spalding, Singapore office, and a member of the firm's International Arbitration Group. He's got a wide practice in commercial, investment treaty and construction arbitrations under many of the institutional rules, ICC, ICSID, SEAC, UNCITRAL, and has been practicing in international arbitration in offices in Paris, London and Singapore for a number of years, admitted in England, Wales and New York and Singapore, and I duly now feel completely inadequate in the presence of both of them. So without any more from me, what we're going to do is hear from them on today's topic of what is the point of investment treaty arbitration, or probably is there really any point anymore in investment treaty arbitration? As is the way, when we get to the end or as we go along, if people have got questions, can they stick them into the chat and or at the end of it, hit the raise your hand button, and hopefully at the end of today we'll have some time for some short questions if people have any. Over to you, fellas. Over to Zachary and Jailin.
Thanks, Duncan.
Jailin, we're in your hands, I think, for
okay. So I thought I would begin by setting out some of the criticisms of investment treaty arbitration, and then turn over to you, Zach, on whether you think those criticisms are valid. So there's been a lot of recent backlash against investment treaty arbitration, with states like Australia saying that they don't want to enter into any more ISDS provisions, with states terminating BITs altogether or just cancelling some of the treaty protections, such as the FET standard. I think before considering some of the common criticisms, it'd be helpful to take a step back to recall the purpose and function of BITs. Historically, I think you thought that BITs would encourage investment because it provides substantive standards as well as a neutral dispute resolution forum too, that were not the local courts. And from an investor's perspective, it would function as a political risk mitigation strategy and insurance policy against a classic scenario of concern about investing in developing countries where you're worried about the rule of law and mass nationalizations. And I think that things have moved on a little bit now, so that most states don't take such overt measures anymore. And there's a real question as to whether countries such as Australia even need ISDS at all to encourage investment, given that, for instance, Australia has such a reputable judiciary and rule of law. To me, I think the current state of play now boils down to essentially a balancing exercise between commitments given to foreign investors as well as measures taken for the public, and balance that against measures taken for the public welfare, for the good of the country in question. And there's been some strong criticism that balance has been shifted unnecessarily in favor of foreign investors to the exclusion of public policy measures. For instance, the recent UN report saying that ISDS is undemocratic and doesn't allow states to legislate on climate change issues or human rights issues. And my personal view is that while there are some cases, I think, of investors challenging what seem to be legitimate public policy concerns, such as the Philip Morris Australia case, I think that with a narrowing down of treaty language and with changing views of arbitrators, it's unlikely that those cases would succeed. And the other criticisms of investment treaty arbitration that the UNCITRAL Working Group has identified include things like that decisions are inconsistent, unpredictable, increased cost of investment treaty arbitration and the length of it, and also lack of impartiality of arbitrators. So I'll be really interested to know what you think of these criticisms and whether you think they're valid.
Well, actually, I'll pick up on the last few that you mentioned, because from my perspective, it's these banal things like cost, time, and perhaps arbitrator partiality, which is threatening the system at the moment. I mean, arbitrators and the arbitration community in general, I think, are quite prepared to say that external forces are going to somehow bring down the system, whether it's the European Commission or tree-hugging greenies or something else. But we're very reluctant to take a good hard look at the mess that we may have created ourselves. And this part of the mess, I think, is first the costs involved. So in one of my pending cases, we've just had submissions on costs, and one party has said that they've spent 65 million on the case, and that's quite high, but it's within the range which is becoming more and more typical. Whereas when I started many years ago, one of these cases, you could tell your client that you could do it for around about $1 million. So there's been a huge inflation in the costs over the last 20, 30 years. Also, the time it takes, I think, is unacceptable, because if you want to be part of real life decision making, if you want to have an impact upon a government's approach to a particular problem or an investor's expectations, then it has to work in real time. And at the moment, 5, 6, 7 years is pretty typical for a case to be resolved, and that's not including what may be subsequent challenges and so on. But one of the problems which I see more and more of, and which I think is quite disturbing, is that I think arbitral decision making has become rather ideological. And this shouldn't come as a massive surprise, because when you look around the world, and in particular at the US Supreme Court, for example, this is very much the reality today. Judicial positions become entrenched, they become ideological, and there's less and less a need or an attempt to justify one's position according to the normal canons of legal interpretation. So the evidence for this, I think, I don't need to share any saucy anecdotes, because the evidence is in the public domain. You see in a lot of these cases that there are often dissents. But what you also see is that the majority who's rendered their award very rarely engages with the arguments of the dissenter. And sometimes it happens vice versa as well. But there's clearly a breakdown in a proper free and fair exchange of ideas on the tribunal. And there's no doubt that some arbitrators are appointed because they're perceived to be more investor-prone or disposed, and some are appointed because they seem to be more predisposed towards states. There's nothing wrong with that per se, because the standards in the treaty are very open-textured. they're capable of different interpretations. So there's nothing, I think, sinister about the fact that people can disagree legitimately about the extent of some of these different standards. But where I think it really is a problem is where those different views are not couched in normal legal tools of legal reasoning. And also, you don't engage with the other person's arguments on the basis of their particular approach to the interpretation of a standard. So these are the problems that, from my perspective, are really causing a systemic threat to the system, which increasingly, and I take note of Australia's position, of course, but increasingly, I think the question is being asked: what is the point, given the costs, given the time, given that the body of decisions is really not contributing to a very coherent and predictable investment law that everyone can rely upon. Increasingly, I think, it probably has always been the case, but it seems to be getting worse over time. It's very difficult for anyone to, I imagine, to give advice to a government or give advice to an investor as to how a dispute is likely to be resolved. And I imagine when that advice is given, the first and the last caveat is that it really just depends on who's sitting on the tribunal. And of course, that's not an acceptable basis. It's not acceptable as a matter of the rule of law, but it's not an acceptable basis to guide the behaviour of investors or states. So perhaps back to you for your reaction to that.
Yeah, I think, yeah, that's really interesting. And I think definitely there's a big element of the predictability, what the outcome is depends on the arbitrator you choose. And I think a good example of that is all the solar cases against Spain, where you have the same measure and completely diverging results. And of course, some of that is attributable to the treaty language in question, or what the particular investor has done, or whether there's particular representations to the investor. But in your dissenting opinion in the Kruk and Spain case, I think you said that there were 24 decisions and 12 of them favored strict liability approach and the other 12 a fault-based approach. So I thought that was really interesting, because obviously that's which arbitrator you choose gets you the result. So yeah, I'll be interested to know what your thoughts are on possible solutions. In particular, there's been a lot of talk about this multilateral investment court, where you'll basically be giving up the crux of investment treaty arbitration, where you get to choose your own arbitrator and you're handing over to a panel of judges. I mean, apart from the obvious logistical difficulties where you would have to enter into a new international convention and somehow annul all the 3,000 BITs in place. Yeah, do you think that would be a good solution to deal with this issue of coherence?
Well, there is quite a lot of anecdotal evidence out there that when states are considering how they're going to regulate a particular sector, then they will have some, at least, consideration of the possibilities of investment treaty arbitration recourse and their exposure to it. So I guess one of the advantages of treaties is that it allows a lawyer, an international lawyer, into the room where the decision's being made, and that person has a voice, because there's a real risk that there may be a substantial damages award. But I think in terms of its future and whether or not you would, as an investor, prefer a contractual basis for your relationship with the state, I think the answer is that the big players, the sophisticated players, would probably always prefer to have a contractual basis for their relationship with the state, with obviously its own dispute resolution provision, and that would typically be international arbitration. I think the sophisticated players who have the leverage would always seek that. But of course, that leaves out a lot of investors who don't have the leverage, who won't be able to have a relationship of at least formal equality with the state by entering into a commercial contract. And it's probably those investors who aren't necessarily the big players, but but nevertheless a very important part of any economy. Who would have the most to lose if the investment treaty system were to become more diluted? Because for them, it tends to be a last resort. I mean, you would think obviously very carefully if you had long-term prospects in a state to take the state on an investment treaty arbitration. So it tends to be a last resort, but I think it's an important last resort, particularly for investors who don't have the leverage to negotiate separate contracts.
Yeah, I agree with that. I think it would definitely be a commercial arbitration would be a great alternative in the case where you have sophisticated parties who have the leverage to get stabilization clauses, to get the state to be a party to the contract. If not, there'll be instances where you just fall outside the scope of the contract if the entity taking the offending act is not the state-owned entity that you've entered into the contract with, or if it's subject to local law. And if the state doesn't make such an overt act to expropriate the property or to terminate the contract, then it may not fall under the terms of the typical clauses on unlawful termination. If they just try to change the economic balance of the contract by increasing taxes, for instance, but the contract itself is subject to local law on changing taxes, then there's no recourse for them.
There's certainly the problem of sovereign risk that remains. So you're quite right that if there is sovereign interference with a commercial contract, then in a typical situation, particularly where the governing law is the law of the host state, then you may be without a remedy as well. But obviously, again, sophisticated investors can deal with that, as you alluded to. So I think given the indeterminacy of investment law today, and I don't think that's going to change overnight, I think given that stability and certainty is so prized among investors, I think you'd always prefer to have your rights and responsibilities set out in a formal document in a commercial contract, and that will be the case going forward. So the question is, to what extent can the investment treaty system be maintained for those who can't negotiate on that basis, and to protect even those sophisticated investors from an abusive recourse to sovereign power.
Well, posing that rhetorical question is probably a good way to sort of bring this to that key point, because you sound, to a degree, somewhat pessimistic, Zachary, about whether it remains fit for purpose, certainly fit for purpose for all. And the impression I get from listening to what you've been saying is that the big end of town, the big end of the market will always try to have independent contractual private arbitration arrangements set in place, and we can probably all understand why. Jolene, that's probably a position I've gathered from listening to you as well. So put yourselves both, if I can pose this question for you. You're king of the trade world or queen of the trade world for a day. You've got a right to recut the system in a way to make it fit for purpose, particularly, as you say, for those that don't have the market share and the clout to be able to negotiate one-on-one contractual arrangements with states. What would you do? What's on the top of the pecking order or on the shopping list to make it more user-friendly, more fit for purpose, to break through cost and time delays, amongst other things, to give certainty to the process?
Perhaps I could start. I would return to the banal problems that I talked about in the opening, and these don't get enough attention because they're not sexy enough, perhaps. But we need to completely overhaul the pleading rules for investment treaty arbitration. It's too often the case that you have these mammoth pleadings which don't really engage with the good points that the other side make. And if they do, that it's in the footnotes. I mean, it's got to that point. So there has to be a radical overhaul of the pleading rules. Pleadings need to be shorter. People need to rely on key documents and not every document ever produced in a particular dispute. And it needs to be far more streamlined, and costs need to come down, because, as I said before, if it's right that what the system really is a fallback for the mid-size investor who can't negotiate a direct contract with the state, then by definition that mid-size investor can't be footing legal bills of tens of millions. So it needs to work for that type of investor. They're the investors that may well fall through the gaps. So costs need to come down. But I think in terms of obviously the time it takes needs to be drastically reduced as well, because again, if you're making real life decisions based upon the progress of a particular litigation, then you need to have that an outcome in a timeline that makes sense for business, or for a government cycle as well. There's no point, and this is why I think so many of these cases don't settle, is that it's just too easy for government officials to say, well, this will be the problem of my successors in 5 years' time, and therefore, why am I going to write a check today when my successors are going to have to pick up the problem anyway? So those banal problems need to be resolved. But in terms of more coherency and less ideological judging, which is, as I said, I see as a real problem at the moment, there needs to be a far more critical community outside perhaps the arbitration community who are taking an interest in the awards. It's obvious that the arbitration community is going to be a bit reluctant to criticize awards, because you might be appearing before the person you're criticizing next week, and that would be rather uncomfortable. But there's surprisingly very little engagement with the substance of awards. There are a lot of academics and NGOs and commentators out there who talk about the system from an external viewpoint. So that they talk about sweeping reforms, that a permanent court, and or the abolition of the system altogether, and so on. But there are actually surprisingly few commentators that criticize awards for what they are, a judicial decision, and that is, I think, causing a lot of detriment, because there are some terrible awards out there, but there's no ramifications, I think, in terms of the reputation of the arbitrators, or very little, because they get buried in the expansive jurisprudence, and no one's calling out the bad awards, and that needs to be done, because that's part of transparency. You need to have a critical community to make sure that arbitrators are kept on their toes and they don't lapse into easy ideological positions.
Jolene, what's on your shopping list in addition or differently?
Well, I agree with all of that. I think in terms of the coherence issues and the cost, there really is no easy solution. While there are discussions about significant overhauls of the system with the multilateral investment court or bilateral investment courts, I think there's still a long way coming, if there's even the political will or ability to make that happen. So working within the confines of the system, I think we could do better with trying to narrow treaty language, or try to specify in the treaty language clearer guidelines. Although that is also difficult, that obviously has its limitations. And then in terms of, as you mentioned about negative effects for arbitrators who are outliers, or maybe even in terms of like when you're trying to narrow down the length of the pleadings, both sides shouldn't be trying to rely on awards that are so far out there and are such outliers that it's not going to work. And I think now there's a tendency that, because a few arbitrators are saying this in a couple of awards, maybe we can try to re-argue these points again. And even if it's closed out, or if the standard has become stricter over time, some people, I think, still try and go back to the older awards and try to relitigate that in the hope that they'll get a sympathetic arbitrator.
Well, we've got a couple of questions that have popped up in the chat room. I don't know if you can see them there on the side, but I'll read them, and if I get them incorrect, people can pop in. First one, considering Working Group 3 has been deliberating on an appellate mechanism, is it eventually desirable that there is a centralised body within the ISDS system so that their rulings can have precedential value and bind other tribunals? Any views?
Well, you run into the costs and the length of the proceedings problem, which I outlined earlier. And this is a particular feature of the appellate mechanism, because what that presupposes is adding another layer upon the existing length of time that it takes to get your first award. Presumably, the appellate mechanism will have far greater powers than a normal court of review for an arbitral award, and so you run the real risk of essentially having another bite of the cherry, a replay of the original dispute. So there's going to be a big cost problem. There's going to be a big time problem, but also there is a difficulty in combining a system where you have the first tribunal selected by the parties and the second tribunal or court selected in some other way. And you see this with the ICSID annulment committee mechanism, because you have in the ICSID system, you have a first tribunal appointed by the parties and the ICSID annulment committee appointed by the ICSID secretariat. And there's always been a perception that the annulment committee doesn't necessarily have any greater legitimacy than the first tribunal. In fact, it could be argued it has less, because the parties haven't had any ownership of the appointment process. So there is perhaps a difficulty there in combining those two different approaches to appointing tribunals within the same system. But I think I worry most of all about the additional costs and delay that this type of mechanism would introduce.
Charlene, are you a supporter or an opponent?
Yeah, I think it would be helpful to have an apex body with precedential value, but the main concern for me is if those apex body judges or arbitrators are going to be appointed by states and all the political issues that comes with.
Okay. A couple of other questions, and I think it's picking up from the last one. Mark has popped in with a question. Isn't the root cause of the ideology problem that the arbitrators are dependent on party appointments and seek to please those who appoint them? Gosh, I don't think we've ever heard that line before. So if we don't have an apex body, should we not have at least some mechanisms to stop parties appointing the arbitrators? Like that age-old problem that doesn't ever seem to have an easy solution. Jolene, you first, if you've got a view on that.
Yeah, I mean, this links to what I was just saying, that the only other alternative to parties appointing the arbitrators would be each state putting forth possible candidates to form like a permanent court or permanent arbitration body. And as someone who typically advises investors, I would rather, as an investor, I would feel safer having a say in appointing an investor, the investor appointing their own arbitrator, rather than leaving it up to this body that could be very politicized. And also, a lot of the discussion right now is to have this body of permanent judges or arbitrators should have only one head. They can't also be counsel, they can't also be experts, and there should also be a fee cap. And there's a real concern, I think, that this could limit the pool of good arbitrators.
Zachary?
I think that the ideological decision-making is not necessarily tied to this desire to have repeat appointments by the same party. I mean, the reality is that there's a very small pool of arbitrators in investment arbitration. It's far worse than for commercial arbitration. It's even smaller. All these people are going to get appointed no matter what they do, I think. And my perception, at least from the side of the bench, is that the people who I would consider to be ideological judges are deeply, by definition, are deeply convinced of the correctness of their own position, regardless of who appoints them in reality. I mean, I think they would maintain that position, whether they're appointed by claimant, respondent, or if they're sitting as chair. It's more that they're not prepared to expose their position to the normal back and forth, the critiques and so on. They're not prepared, in other words, to take an open view of the development of the law. That their position is entrenched, and they're not going to budge, and they're not going to listen to contrary arguments. So I think it's less among the very small group of arbitrators who are active in investment arbitration. It's less of a desire for reappointments by the same side, but more about not having their views challenged and being no longer susceptible to taking an open mind about certain views. And as I said, my exhibit number one for making this statement is the awards and the dissents themselves, where there's just very little engagement between different views on the same tribunal. In many cases, the majority won't even acknowledge that there's a dissent, and to my mind, that's rather unfortunate.
Probably on that last point, there was a question from Amanda Lees. I think it's on that last point, Amanda. It was some little while ago. You put that question on the chat room. So if I get this out of context, please click on the sound and correct me. But the question was, do you think the lack of engagement on the substance, that is the substance by the arbitrators, as I understand it, is because of a fear of challenge as the challenge to the arbitrator, or the arbitrator having their words to come back to bite them in another case? Amanda, have I put that correctly? If not, can you re-put it?
Oh, thanks, Duncan. Sorry, Zachary, I was picking up your point about the fact that there isn't any commentary about the substance of arbitration awards, and that there's some truly dreadful awards out there, but they're never criticised. The community doesn't engage with them. And I'm wondering whether or not this is partly because of the fear that people have of their articles being used, one, to either prevent them from getting appointments, or to challenge them if they have appointments on the basis that they have views on certain issues and on certain awards. And that even if you're acting as counsel only, which I do, that you might have to argue based on one of these awards, and then your own words will come back to bite you. And given that community is so small, there's not the same degree perhaps of a critical look because of those fears then perhaps there would be if there was a bigger community, and also if there wasn't, I suppose, the fear of being challenged on a sort of issue basis, on the basis of your views.
Well, I could talk from personal experience because I do write, I do publish. I am challenged occasionally for views that are being published. They're generally not successful, but there's always a risk, and so it's up to the individual to decide whether or not they run that risk. I have had difficulties with some of my colleagues on tribunals because I've criticised their awards in writing in the past, and those moments passed, and everyone's adult enough to move on. But I think what's really lacking, we can't put too much emphasis on the arbitrators and the council supplying the critical community. It has to come from the outside to some extent. We need a community of commentators who are not necessarily participants in the system. And this is the paradox, I guess, is that the people who are not practicing don't tend to engage with the substance of awards. Instead, they're far more interested in the systemic problems, the proposals for reform, the proposals to get rid of it altogether, the idea that the whole thing is an elaborate conspiracy, and so on. I'm caricaturing it a little bit, but there isn't that outside community who are taking a critical view, but who are also prepared to accept the system for what it is and try to improve it from within, from taking an internal perspective rather than an external perspective. And I think that's really missing at the moment.
And is that something that academics like yourself should, people who have academic positions should be supplying more, and perhaps because there is obviously, which I think is a good thing, more people are arbitrators who are also probably international law professors and so forth. Is that what's holding it back? I mean, you would think there would be more books written criticising the substance of some of these awards.
Look, it's a fine line to walk, because when I was counsel, I never really enjoyed appearing before an arbitrator who'd never been a counsel, because they don't understand or have no first-hand knowledge of all the pressures that counsel are under. And I always had difficulties being in that situation as counsel. So I certainly wouldn't advocate that all power to the professors by any stretch. That they're at the end of the day, running, especially from a chair's perspective, running an arbitration is an art and a science which requires a lot of, I think, prior experience to do well and to do properly and to meet the expectations of both parties. So I don't think empowering professors necessarily will solve the problem. It's more you need external voices. You need people who don't have a stake in the practice of arbitration to take a critical view. Critical view, obviously, that doesn't prohibit anyone from endorsing awards or giving praise where it's due. But there's a lot of awards which shouldn't be, to pick up on another point, which shouldn't be cited all the time, where we shouldn't be spending hours debating, because they're terrible in the sense that they can't be justified going back to first principles. But that work to demonstrate that could be done by external commentators. So I have a lot of students and who write PhDs and take a critical view, but unfortunately what then happens is they join the big firms and they stop writing, and that voice is lost as a critical voice.
We're getting towards the end of our time, but before we cut off, we've got a number of people on the call who might have a view on this. We've heard a lot about the problems, cost, time, etc. A lot of what's been said by Zachary are in commercial arbitration things and solutions that are brought to bear by the strength of the tribunals concerned, i.e. deciding to take some procedural control over what's happening in a way to cut through and get to centralised issues, having statements of essential fact and the like. So with that sort of wider commercial background and others that are listening on the call, has anyone got any practical solutions to offer to cut through the various problems that have been raised today that they might want to proffer up for consideration?
Just very quickly, though, just to pick up on that point, I mean, I sit in many more commercial arbitrations because there's more of them. It's chalk and cheese. I mean, this is what I find extraordinary. It's like entering a different system. My experience in commercial arbitration is far more pragmatic. There's far less wasted paper and pleadings that run on unduly and so on. So it'd be very interesting to hear from people who practice more predominantly in commercial arbitration, because I think there are solutions there, but for various reasons we don't adopt them in investment arbitration.
Come on, people, don't be shy. Here's your chance. Well, I'm surprised by the reticence, particularly as a number of people on here I know have sat as arbitrators, and they've taken the matters by the scruff of the neck early on, bringing people in at the very early stage in the arbitrations, trying to understand what the true issues are, organising early expert conferrals before evidence has gone on to get to the nub of what might be a technical issue that's separating matters, early openings and the like. There are any number of mechanisms available in the commercial arbitration space designed to cut through. In particular, my favourite one of minimising the memorial process as a vehicle for allowing parties to go off and vent frustration rather than to identify issue. there's a lot to be said in the appropriate cases for something more in the nature of old form pleading to actually get to and isolate the various point up front, or at the very least after the memorial process to require that to distill. So I hear what you're saying. I completely embrace the idea that in a commercial arbitration sense, it's more the norm these days to try to cut through rather than to obfuscate. And it is, at least for my part, listening to this today, of concern that the lack of party utilisation of some of these processes within this area of the arbitration system is hastening its unattractiveness to people in the market.
To a large extent, the future success of commercial arbitration is going to depend upon whether it can resist some of the excesses that we see in investment arbitration. Because we have a common pool to some extent of arbitrators who do both, and obviously counsel, that there's a real risk, I think, that the bad habits that are becoming typical in investment arbitration will seep into commercial arbitration, and all the things that you've just said, all the common sense, pragmatic mechanisms for rolling up one's sleeves and just getting to the point will be diluted. And that's a real fear.
Jailin, last words from you?
I don't have anything further.
Okay, well, I don't see anyone putting their hand up at the moment in the chat or any further questions, and we've been going a significant amount of time. So, Jailin, Zachary, thank you very much for what's been a wonderful talk this afternoon, a wonderful conversation. Thank you for dialing back in, Zachary. Once the UK decided to melt down, we're grateful. We're grateful to both of you for your time.
Thank you very much.
Thank you. Excellent.